Ladies and gentlemen, you are welcome to the CRCICA Dispute Board Rules launch event. I would like to say some words about CRCICA background to start with. The Cairo Regional Center for International Commercial Arbitration, the CRCICA, is an independent, non-profit international organization. The center was established in 1979 under the auspices of the Asian African Legal Consultative Organization, ALCO, in pursuance of its decision taken at the Doha session in 1978 to establish regional centers for international commercial arbitration in Asia and Africa. The CRCICA has a board of trustees consisting of 24 members from amongst eminent African and Asian personalities specialized in the fields of international arbitration, law, business, trade and investment, and international relations, in addition to members from outside Africa and Asia. The term of the Board of Trustees is 4 years, which may be renewed once for a similar term unless otherwise determined due to special circumstances. Their members carry out the functions provided for in the bylaws of the Board of Trustees, and in particular, appointing the director of the center in consultation with the with ALCO, the Asian African Legal Consultative Organization. Additionally, CRCICA is composed of an advisory committee which consists of up to 19 members appointed by the director of the center amongst the members of the Board of Trustees, as well as other eminent African, Asian, or from outside the two continents, from amongst the members, in the fields of international arbitration and trade, specialized in the fields of international arbitration and trade. The term of the advisory committee is also 4 years, which may be renewed once for a similar term, unless otherwise determined due to special circumstances. Their members carried out the functions provided for in the bylaws of the advisory committee. These functions include deciding upon requests for challenge of arbitrators and dispute board members now, and requests not to proceed with arbitration proceedings. The CRCICA long-standing experience in the resolution of international disputes did not remain unnoticed. The center was awarded numerous awards for its fast dispute resolution, effective cost optimization, and professional services. By way of example, in 2013, the CRCICA won the Global Arbitration Review Guide to Regional Arbitration Award for an arbitral institution that impressed. It won the same prize also in 2019. Likewise, international and regional organizations numerous times paid tribute to the services of excellent standard provided by CRCICA. Noteworthy is the assessment report mandated by the African Development Bank in 2014, mentioning CRCICA as one of the best arbitration centers across the African continent and elsewhere. Not only CRCICA endeavors to meet today's needs, but the center also aims to innovate by addressing incoming challenges. We previously invested massively in our hearing facilities and video conferencing capabilities, and in technology in general. Thus, when the COVID-19 pandemic hit the world, we were able to effortlessly carry out our activities by switching to electronic means, both for hearings and submissions. I would like to speak now about CRCICA's initiative and reasoning for issuing the CRCICA Dispute Board Rules, along with its arbitration and mediation rules. This webinar, as you see, is also about innovation and transformation. In Africa, the current pipeline of infrastructure projects amounts to no less than 2.5 trillion US dollars. These construction projects, no matter how small, tend to result in litigation or arbitration. This is why dispute boards are tremendously used in this sector to resolve the disagreements before they escalate. As of today, over 250 billion US dollars worth of construction and other projects worldwide have successfully utilized dispute boards. Thus, as an arbitral institution, CRCICA could no longer ignore the high demand in this industry for specific dispute board rules. Therefore, and this is consistent with our long-standing tradition of innovation, we are now addressing the issue by launching our 2021 dispute board rules. We knew we would not have to draft them from scratch, given that the center already had experience in dispute boards. Indeed, CRCICA has been agreed upon as an appointing authority of dispute board provided for in infrastructure contracts financed by the World Bank. As such, the center has registered 2 dispute board proceedings arising out of such contracts. Thus, in September 2019, a dispute board committee was appointed by CRCICA for the purpose of drafting dispute board rules. It included renowned experts in the field of dispute boards and institutional arbitration from diverse regions of the world. Accordingly, I would like to thank their members, such as the experts coming from all the Middle East, namely Professor Dr. Mohammed Abdurraouf, engineer and lawyer Mohammed El-Haggan, Dr. Walid Al-Nimr, Mr. Ahmed Ibrahim, Dr. Inji Sirag, and the provider of the first draft, Professor Dr. Ahmed Waly, and the tremendous work done by Engineer Aisha Nadar in reviewing and moderating the work of the committee. Allow me also to pay tribute to the contribution of our colleagues from Europe, Professor Nael Bunni, who is also from our region, Dr. Cyril Chern, Professor Bernardo Cremades, as well as Mr. Jeremy Nicholson. CRCICA is also indebted to our counterparts, Mr. Henry Masunda and Ms. Suzanne Rattray from Zambia, and Mr. Ziyong Li from China. The CRCICA Dispute Board Committee was also, as I have mentioned, moderated by Engineer Aisha Nadar and Professor Ahmed Waly, my colleagues at CRCICA, Ms. Heba Salim and Dr. Muhammad Hafiz. The Arabic French versions of the rules were completed, as the case may be, by Ms. Lobna Hazim from CRCICA, Ms. Malak Lotfi from CRCICA, Ms. Audrey Plez and Ms. Laurie Labaye, who are French-speaking lawyers and are or were intern at CRCICA, and were finally reviewed, the Arabic version, notably by Professor Dr. Fathi Wali and Dr. Dalia Hussein, the Deputy Director of the CRCICA. I thank you all for your precious contribution. Next, with the assistance of Professor Ahmed Waly, we prepared the first draft of the CRCICA Dispute Board Rules and circulated to the Dispute Board Committee in October 2019. We then received the editing and comments on the first draft from all the members of the committee. Next, CRCICA, through a small number of the drafting members committee headed by Aisha Nadar, finalized the second draft, which was circulated to the Dispute Board Committee in December 2019. Following this colossal amount of work on several drafts, with the further inputs of the committee, we were able to finally issue the CRCICA Dispute Board Rules in August 2021, in English and in Arabic. Just like we did with our CRCICA arbitration rules, we are now almost finalizing the French version of the Dispute Board Rules so that the greatest number of people worldwide can recourse to them. And we are open to other languages, by the way. For the same purpose, we published dispute board model clauses that the parties are strongly encouraged to include in their contract. The CRCICA dispute board rules provide for each type of the dispute boards: dispute review board and dispute adjudication boards. The parties can also choose either standard dispute board model clauses or multi-tiered dispute board model clauses, which can be found in Annex A to the dispute board rules. Finally, Annex B contains a model dispute board member agreement, the DBMA, covering such matters as the dispute board members' undertaking, remuneration, and the duration of the agreement, amongst other matters. For choosing their international adjudicators or dispute board members, the parties can also rely on CRCICA's panel, which includes eminent personalities from all over the world, including the CRCICA Dispute Board Committee. Before letting my colleagues discuss the content in detail, I would like to mention one of the salient features of our dispute board rules, namely the optional administrative services. Indeed, under Article 18 of the CRCICA Dispute Board Rules, the Center can provide such service upon the request of either party or the dispute board members. In other words, the Center will be able to facilitate the communications between the parties and the DB members, to provide necessary practical arrangements for meetings and hearings and other case management services as set out in the CRCICA Dispute Board Rules. In other words, the Center will endeavor to support and guide the parties at each stage of the adjudication process. Now, I would like to present our dear distinguished moderator, Ms. Aisha Nadar. I will need a lot of time to, present her curriculum vitae, so I will be very brief for the purpose of this webinar. So I will be very brief. I would say that Aisha is one of the most renowned practitioners and expert worldwide in the field of procurement and contract management and arbitration under various rules, mediation, dispute boards, and expert witness. Over 30 years of hands-on international experience in all phases of procurement, project execution, and dispute resolution of complex infrastructure and defense systems. She has also acted consultant to parties and party counsel on case evaluation and dispute management strategy development. She has also served as consultant responsible for carrying out assignments related to dispute resolution for organizations such as the World Bank, Mediation in Construction, the USAID, and the USDOD. She is also a member of several committees and task groups, namely the CRCICA Advisory Committee, the panel of conciliators of the ICSID since 2020 until present. She is an adjudicator, FIDIC President's List from 2015 until 2020, if I'm not wrong, or to present. You can say it when you take the floor. A member of the FIDIC board and a co-chair of the ICC task force for update of ICC final report on construction industry arbitrations. Aisha, we are proud that you are Egyptian, but Aisha is also Swedish and American, and she is fluent in English and Arabic. It's my pleasure to give the floor to our esteemed moderator, Ms. Aisha Nadar.
Dr. Ismail, thank you for this way too generous introduction and way too long, because I want to not only add my welcome to that of yours today. My role is that to be the moderator, and I am delighted to be here and have the privilege to join my esteemed panel in launching the newly introduced CRCICA Dispute Board Rules. Our panel they need no introduction, but I will say a few words about each. But before doing that, I think as a panel, we agreed we'd like to get to know the audience a little bit more before we dive in and know who we're speaking to. So we're going to start off the session with a few poll questions. So if I can turn to Yahya, and can we please put up the first question? And I invite the audience to answer quickly because we're going to go through these quickly. So let's see what the results are here. Do we get to see the results before we go to the second question? So we have a fair number with experience of dispute boards. Now, second question, Yahya, please. And this is just to help us get a feel for the audience of what sector, how you participated for those of you who might have had a role in dispute boards, so we could better address and target. And hurry and answer, because I'm going to ask Yahya for the results really quickly. So Yahya, in 10 seconds, please give us the results. So it's an even split between acting as counsel, participating as a contractor, engineer, employer, which is fantastic. We have a nice mix. And now finally, the third question. And I apologize, I see some questions on the Q&A thinking that this is going a little too fast. And Mr. Engineer Akordi saying, what about expert opinion? But we're just kind of getting a feel, so nothing specific, and we won't hold you to your answers. So hurry up and answer the third question, and then we want to know a little bit about where you heard about the CRCICA dispute board rules. And I'll give it another 10 seconds before I ask Yahya to put up the answers. So Yahya, go ahead and see where we're at with the. So, well, good. I mean, this is nice to know that people had heard about the CRCICA dispute board rules before this event, and indeed they were they became effective in August. But we're formally launching in now, and we are so delighted that you can join us and be with us today, and so we can have a better flavor for those rules. And what I noted is many of you in the audience are practitioners, and some are experts, and some have participated with the contractor and the employer. But I would assume that everybody around this virtual table or in this virtual platform would agree that long-term projects are prone to disputes. And this is particularly so as many of us are practicing in the construction area. But we would also probably agree that today's cost-sensitive clients don't only want to resolve disputes. And we've learned this really through COVID, or it's been accentuated through the COVID times. But these cost-sensitive clients are now demanding that the legal market focus on project success, and if at all possible, to avoid disputes in the first instance, and only leave those that cannot be avoided to resolution. It is for that reason that Dr. Ismail has outlined so eloquently that CRCICA embarked on the dispute board rule journey. Now, the task at hand today is to walk through the innovations in dispute management and to introduce the dispute board rules. And we will do so by first engaging in short presentations by each of the speakers, and then engaging the audience and the panel members in a round table with a question and answer session. For the presentations, we're going to first introduce disputes and dispute management in context and the dispute board, the CRCICA dispute board rules in context. So for that purpose, we're joined by Dr. Nael Bunni to introduce disputes in context. Of course, Dr. Bunni needs no introduction. And he has been a mentor to many, including myself. But what you might not know about Dr. Bunni is that he was one of the founding principal persons responsible for introducing the use of ADR, or alternative dispute resolution methods, in the FIDIC standard forms. And this goes back many, many years. And in addition to that, Dr. Bunni is one of the principal drafters of the dispute board rules of FIDIC 2017. But that, not only that, he's also been involved with the ICC dispute board rules from 2004 and in 2015, when he, with a small group of people, was responsible for drafting those rules. So I'm assuming that we can all agree that he's very well placed to introduce to us what dispute management is and how dispute boards play a role in this context. Nael will be followed by Dr. Waly. And as Dr. Ismail said, he was the author of the first draft of the dispute board rules that you have hopefully in your hands today. Dr. Waly is a managing partner of Waly Arbitration and Contract Administration firm. He has dual degrees in engineering and law, and he has more than 25 years experience in construction contract administration and dispute resolution. He acts as arbitrator, mediator, adjudicator, and expert witness, and also counsel on several ad hoc and institutional disputes. And if that's not enough, he, in his other life, he is an associate professor at Helwan University in the Faculty of Engineering. So once we set the stage with the CRCICA dispute board rules, and Nael giving us that flavor of dispute management in context, we'll then turn to our practitioners to see how well CRCICA did or didn't do in achieving the aim of answering the demand of industry and providing a good set of dispute board rules. And for that, we turn to Mr. Charles Blamire-Brown and Dr. Elke Christina Paschl. Sorry, I mispronounced. First, Charles is a partner and solicitor advocate at Pinsent Masons, specializing in representing clients as counsel and advocate in international arbitration, dispute boards, and other alternative dispute resolution procedures in connection with major construction, infrastructure, and energy projects. His experience spans projects in UK, Europe, CIS, Africa, Middle East, and Central America. Charles is going to share with us a comparative view of the rules, FIDIC, ICC, and CRCICA, looking at some salient features. And then Elke, if I may go away from formalities, that everybody is a professor and a doctor, and I'm not. So I'm going to go away from formalities and then continue by first name, if you don't mind. So Elke has more than 25 years of professional experience in commercial, corporate, and finance law matters, which she gained in renowned law firms in commercial banks in London and Vienna. Since 2016, she has been with the African Development Bank based in Tunis and Abidjan in the Ivory Coast, where she not only was responsible for structuring and negotiating public and private sector projects, including the finance structure and export finance projects. Her present role now is as Chief Legal Counsel in the front office of the Fiduciary and Inspection Department of the African Development Bank, and she's in charge of developing policies and strategies in operational procurement matters, and she will be sharing the perspective of a user from the African Development Bank or the Development Bank's perspective. So without further ado, I am gonna turn it over to Nael. Nael, the floor is yours, and I will say nothing until Elke finishes her presentation. So, but I'll keep you all to time.
Thank you very much, Aisha. Good evening, ladies and gentlemen. Historically, the dispute board concept originated in the late 1960s in the United States in the form of what is now known as a dispute review board. Its first recorded use was on Boundary Dam in Washington. This led to the US National Committee on Tunneling Technology in 1972 to sponsor a study to develop recommendations for improved contracting methods in the United States. The study report was published in 1974, providing many recommendations that were adopted by various owners and consulting engineers, affirming that some mechanism was required to settle disagreements as they arise, rather than leaving them to fester and develop into intransigent disputes. With its 18 advantages, as I explain in my book, The FIDIC Forms of Contract, the dispute review board mechanism was chosen as the answer for that devised mechanism. So in 1975, a review board was used on the construction of the second bore of the Eisenhower Tunnel in Colorado and was acclaimed to be an overwhelming success. Other successful DRBs followed, and their use became popular not only in underground structures, but also in highways, building, and civil engineering projects. Statistics published in 2004 put the number of known projects using dispute board since 1988 at about 1,100, valued at over $75 billion, with approximately 1,300 disputes having been tackled and resolved successfully. Internationally, the first project that incorporated use of a dispute review board was the Ayacajon Hydro project in Honduras in 1980. Since then, many projects all over the world have successfully used dispute review board. Then, in 1995, the use of the DRBs in international construction received major encouragement when the World Bank produced the first edition of standard bidding documents for the procurement of works of civil engineering construction, that's the SBDW, and included as one of its mandatory provisions the use of a DRB for the resolution of disputes between the employer or owner and the contractor. Furthermore, in the same year, FIDIC introduced its Orange Book in 1995 for design-build projects and chose to use the concept of dispute boards in its dispute settlement procedures. However, FIDIC had to change the process from a review board, where the board issues a recommendation, to an adjudication board, where the board issues a decision, in order to emulate the action of a decision-making process as required from the engineer on a project. As you know, the engineer under the FIDIC contract is required to determine a dispute rather than to make a recommendation as to how the dispute should be resolved. This was followed in November 1996 by FIDIC when it introduced its supplement to the fourth edition of the Red Book and replaced the traditional role of the engineer with the dispute adjudication board and the decision-making process. This significant change of policy by FIDIC was the result of the criticisms that it was receiving from all sectors of the construction industry regarding the independence of the engineer as a decision maker in disputes between the owner and the contractor, when in fact the engineer was appointed by the owner to carry out his function as a designer, but also his function as a dispute resolver. Then, in September 1999, the Dispute Adjudication Board was introduced into the new suite of FIDIC's standard forms of contract, the red, yellow, and silver books, as the first step in the dispute settlement procedure. These forms of contract included as an appendix general conditions of dispute adjudication agreement and the procedural rules for the use of dispute adjudication boards. In June 2004, the ICC in Paris adopted the use of dispute boards in a set of rules of its own, which incorporated dispute review boards, dispute adjudication boards, and dispute boards, which can be used in either form to review either form of a review board or an adjudication board, as the parties chose later on during the execution of the project, depending on whichever is more profitable for the dispute avoidance and dispute resolution. Now, moving on from dispute resolution to dispute avoidance, it's interesting to note that when FIDIC changed the role of the DRB to DAB in 1995, it did not forget the important aspect of dispute avoidance. However, it only referred to it in a very short paragraph of 2.5 lines within subclause 20.2, which stated as follows. It stated that if at any time the parties do so agree, they may jointly refer a matter to the DAB for it to give its opinion. Neither party shall consult the DAB on any matter without the agreement of the other party. That's all that it stated. But despite its relative obscurity, in the 1999 FIDIC forms, dispute avoidance proved to be very useful in many projects where the parties to the contract were intent on resolving their problems amicably and quickly, rather than going the full way to arbitration. Thus, to arbitration through dispute boards, of course. Thus, the need for a higher degree of recognition of dispute avoidance resulted in upgrading that paragraph in subclause 20.2 of the Red Book to a full subclause when the Gold Book was introduced by FIDIC in 2008 for design, build, and operate projects. That was its subclause 20.5. It was then that a new term was introduced into the dispute arrangement or the dispute settlement procedures. And that term was disagreement, to indicate a step prior to the occurrence of a dispute. The effect of dispute avoidance on project management as a whole was felt more clearly in projects where construction was complex and where the owner wanted its project to be completed on time, within budget, and with the quality set out in its drawings and specifications. Demand for dispute avoidance grew further. And so in the latest edition of the FIDIC Red Book, that's the 2017 edition, the Dispute Adjudication Board became the Dispute Avoidance / Adjudication Board, and formally now introduced avoidance as part of the role of the dispute board. and a new subclause, subclause 21.3, was introduced, which is to a large extent similar to subclause 20.5 of the Gold Book, and again, with the term disagreement embedded in it as a step within the process of the manifestation of a dispute. I would like to conclude this presentation by emphasizing that the effect of dispute management on project management is a very substantial one, which must be considered when deciding on the risks relating to time, budget, and quality for the project, the essential feature of a project. Ladies and gentlemen, thank you for listening to me, and I wish you a very happy question time. Aisha.
Thank you, Nael. I now, without further ado, turn it over to Ahmed. You're on mute.
Okay, thank you, Aisha, for your introduction earlier. I think one of the toughest tasks for anyone is to speak after Dr. Bunni, so I will do my best. It is indeed my pleasure and an honor to be amongst this panel of distinguished professors and dear colleagues, and especially when it is moderated by you, Aisha. First, I would like to express my sincere appreciation to CRCICA for allowing me to participate in drafting the dispute board rules and to be part of this fantastic effort. Due to the increase of the use of adjudication in Egypt and the region, especially as Dr. Ismail said, due to the presence of several multilateral development banks and funding agencies for the mega infrastructure projects in Egypt and the region, we as practitioners have been talking with CRCICA for many years about the need for having our own rules for dispute boards. I remember quite well the phone call I received back in 2018 from Dr. Selim, requesting me to start preparing the first draft for the rules. The mandate was clear. Dr. Selim wanted a comprehensive and detailed rules, though concise and to the point, that represent best practices worldwide, yet adapted to suit Egypt, the MENA region, and Africa at large. Rules that are impartial to consider the views of all parties involved, the parties to the dispute and the DB members, and to lead to, as much as possible, a cost-effective procedure. The first step was then to review the dispute board rules published by the most reputable international centers. We prepared a detailed comparison of these rules article by article in an attempt to be acquainted with the different approaches and come up with the best way to deal with the issue in hand. The first draft was communicated with CRCICA by the end of 2018. Then the real work started. At that time, I discovered that the first draft represents maybe less than 10% of the required effort. CRCICA formed a drafting committee and invited eminent international and regional experts in the field who started to review the first draft. Rounds and rounds of communications and meetings were conducted to come up finally with the final draft, which is before you today. I'm going to briefly, in order to present the rules in detail, I will need at least 2 hours. So I will just go through the rules in brief. If you go through the rules, you will find it divided into 7 sections and 2 annexes. The first section of the rules cover some introductory rules. Article 1 includes the definitions, and I think it's very important to understand the definitions. For example, the definition of dispute. As Dr. Bunni said, this is one of the issues that are important to understand before starting a referral. So we have the definitions in Article 1 and the application of the rules in Article 2. And then Section 2 of the rules will covers the types of dispute boards. CRCICA dispute boards cover the two dispute board types, the dispute review board and the dispute adjudication board. The dispute review board will render a recommendation that is not binding unless a specific time elapses, and the dispute adjudication board will render a decision that is binding and may become final after the elapse of a specific time. Section 3 covers the establishment of the dispute board, and while drafting this article, we were very keen to respect the principle of parties' autonomy. So whenever the parties in their agreement agreed on a particular method for example, the appointment of the dispute board, then we will respect the parties' autonomy. If no agreement, then the rules will apply. So Article 5, 6, 7, and 8 covers the appointment of the dispute board members, how they are appointed if parties did not agree on that. The impartiality and independence of the dispute board members, which is definitely an essential, essential in the dispute member, and the DB members' qualifications and obligations, as well as a dispute board member agreement, which a model is in Annex 2 of the rules. Section number 4 includes the control of the proceedings. So the provision of information, the Article 9 requires the parties to assist the dispute board members in providing information and help the dispute board members as efficiently as possible. Article 10 covers the site visits and meetings. If there is an agreement or if there is a need, then there will be specific number of site visits and meetings during the procedure. If not, then, for example, a minimum of a meeting every 4 months is prescribed by the rules. Article 11 covers the written notifications or communication and some time limits that the parties and the members shall abide by. Article 12 covers commencement and completion of the DB's activities. The commencement is when each member sign the agreement with the parties, and the completion is when both parties agree to that the mission is completed. The 5th section is very important, and it covers the informal dispute avoidance. We talked about dispute review board, dispute adjudication board. In both types, one of the main tasks of the dispute board member is to attempt to avoid the dispute before it occurs. And this is, I think, one of the main features of the dispute board, boards. Article 14 discusses the dispute resolution, the formal referrals. When can a party refer a dispute to the dispute board? How hearings are conducted are covered in Article 15, and the conclusions, and by conclusions we are referring to either recommendation in dispute review boards or decision if we are talking about the dispute adjudication board. Article 17 covers the powers of the dispute board during the procedure. Section 6, as Dr. Ismail presented, is one of the important sections, and one of the salient features of the rules is the optional administrative services of the center. The center provides a wide range of administrative services that I believe are indispensable for the effective conduct of the procedure. And the final section, which is section 7, covers the administrative fees of the center and compensation of the dispute board members. And as I said, we have 2 annexes to the dispute board rules. The first one includes the dispute board clause for a DRB followed by arbitration if required, and dispute board clause for a DAB followed by arbitration if required. And Annex B includes the dispute board member agreement, the DBMA. Thank you, Aisha.
Thank you. Dr. Ahmed, for this for the force of what's inside the dispute board rules. And so Nael set up for us the context of dispute management, and Ahmed set up for us what CRCICA has attempted to do. Now I'm going to turn it over to the practitioners and do an assessment. So Charles, can I turn it over to you and kind of walk us through the salient features of what CRCICA tried to do and compare and contrast to what FIDIC has done and what the ICC has done?
Of course, and with pleasure, Aisha. So as Aisha mentioned, I'm going to provide some user perspectives on the rules. Now, I specialize in representing clients in infrastructure energy sectors on primarily construction disputes relating to major projects. So in the interests of full disclosure, my perspective and experience of dispute boards is from this context. But I should flag, and it's a point that I think is important, that dispute boards, I think, very much have an application beyond these sectors and types of disputes. Essentially, they should be applicable to any long to mid-term relational contract. And I, and certainly some of my colleagues at Pinsent Masons, are starting to see dispute boards being considered in other sectors other than construction, such as IT contracts and so on. So it's very much a sign of the future and of things to come. But for those of us like me and others involved in the construction sector, the concept of a dispute board is, of course, likely to be a very familiar one. And I think most of us will be familiar with the procedural rules and conditions provided by FIDIC. A number of institutions such as the ICC have produced their own dispute board rules. And as Aisha mentioned in commenting on the CRCICA rules, I thought I'd draw some comparisons between those 2 other sets of rules. Now, rather than a line-by-line review, and I completely agree with Dr. Waly, I think it would take longer than 2 hours, with respect, Dr. Waly, to do that. I thought I would break my review down into a few key topics, ranging from some general comments on layout to the different types of dispute boards envisaged, and some comments on procedure. So turning first to some general comments on what has been provided by CRCICA and the layout, and that's been aptly summarized by Dr. Waly and Dr. Ismail, that we have a package of dispute board rules, template contract clauses, and a template dispute board member agreement. And the only comment I would probably make is that the CRCICA layout, I think, reads to me anyway as being similar to the ICC rules, with the majority of provisions located in the procedural rules themselves. The contract clauses and dispute board member agreement are welcome in that they are relatively succinct. And this, I think, compares with a much more even spread of provisions in the FIDIC contract across as clauses 21, the procedural rules and the general conditions of DAAB agreement. And I think this is perhaps borne out of the fact that the CRCICA rules, like the ICC rules, are not contract specific. Moving then on to the next topic, and an interesting difference, I think, between the various rules are the different types of dispute boards envisaged by the different rules. In FIDIC, we have the concept of a dispute avoidance and adjudication board in the 2017 edition, which can provide informal assistance to the parties to resolve disputes, as well as issue binding decisions in respect of disputes. These decisions are binding on the parties, even if a notice of dissatisfaction is issued. They must give effect until an arbitral tribunal, for example, has finally determined the merits of the dispute. The ICC, however, provides not only for a dispute adjudication board like FIDIC, which issues decisions, but the ICC rules also provide for a dispute review board, which issues recommendations. And the same two types of boards feature in the CRCICA rules. And as Dr. Waly mentioned, these recommendations issued by the DRB are not immediately binding on the parties, but they can become final and binding if the parties do not issue any notices of dissatisfaction. Now, just one point to note is that the ICC rules also provide for a combined dispute board, which can issue both decisions and recommendations. And also another point to note is that in all circumstances, under both the ICC, the CRCICA rules, the dispute boards can carry out an informal assistance function as well as issuing their recommendations or decisions. Now, given the prevalence of FIDIC DABs and DAABs issuing decisions, I'm not sure, well, certainly in my experience, that DRBs, dispute review boards, issuing recommendations are so familiar, particularly in the context of construction. I've certainly had experience of DRBs, and I think they can be very effective. Parties are, in theory at least, more likely to engage in using these if they know that they're not going to be bound by the decision in the short term, provided they issue a notice of dissatisfaction. So the non-binding nature of those decisions, I think, can be attractive. However, the flip side is that given there is no teeth in parties having to comply with the recommendations in the short term, in practice, certainly I've seen parties just issuing notices of dissatisfaction as a matter of course in respect of recommendations in order to preserve their rights to challenge and avoid these recommendations becoming final and binding. So I think the benefits sometimes of DRBs are sometimes lost, particularly in the construction context, where there is a value in getting that decision, that binding decision, and ensuring cash flow is maintained. Moving then on to the next one, this is problems with providing informal assistance. And a common problem faced by dispute boards is how to maintain independence and impartiality in carrying out the role of providing informal assistance, but also being asked to act as a sort of a pseudo mediator in that role, but then also acting as an adjudicator in issuing recommendations and decisions. And in trying, as I say, to get parties to avoid or resolve their disputes, there may be a temptation for the dispute board to act as a quasi-mediator and want to meet with the parties separately. However, in doing so, I think the dispute board faces the potential accusation that it has potentially obtained information in this process without the other party having opportunity to know what has been provided, and information which is potentially confidential in those individual separate meetings. And the answer to this existential dilemma, as I'm going to call it, may well differ under different legal systems. There is certainly English law authority in the case of Glencop Development and Ben Barrett, which suggests that the roles of acting as quasi-mediator and adjudicator may be incompatible. However, presumably the parties can agree to the dispute board carrying out such a different role. And I think FIDIC thinks so and suggests that the DAAB should not meet separately unless there is consent to do so. However, even if the parties provide consent, I don't think that's necessarily a panacea to the issue, because without full transparency as to what has gone on and what has been discussed in those individual separate meetings with the parties, the dispute board may still be exposed to later accusations of impartiality. I think, interestingly, the CRCICA rules are more explicit in ensuring that there can be no suggestion of meeting parties separately, and that's clarified in Article 6. And I think that is a welcome and personally a right approach for the function of dispute boards. I'm conscious of time, and Aisha is probably going to tell me to wrap it up. So I just wanted to quickly mention two things. Firstly, the constitution of the dispute board. In terms of numbers of dispute board members, the default position under CRCICA, like ICC, like FIDIC, is 3 dispute board members. However, one thing I'm really pleased to see noted in the CRCICA dispute board rules, which aren't in the others, is the possibility of actually having more members than just 1 or 3 dispute board members. I was on a project council on the London 2012 Olympics many years ago. And on that, we set up 2 panels, one comprising a panel of adjudicators, the other a panel of experts to provide informal assistance. And on both those occasions, the panels were made up of a number of members, much more than 3. And then finally, if I may, just 2 comments on the procedure and one on notices of dissatisfaction. In terms of procedure, we're all familiar with the FIDIC procedure for reaching a decision. Parties have 84 days, the dispute board has 84 days in which to reach its decision. But in terms of the procedure for doing so, that is effectively left up to the dispute board. Now, compare this with the ICC rules, which I think are more prescriptive. For example, it's the requirements of the referral, the statement of case. And also the ICC rules provide for the parties to provide a response within 30 days. And I think the CRCICA rules are similarly quite prescriptive in providing requirements for a referral, a reply, a response, and also a reply within, for me, quite short timescales. And I think there's a fine balance there between being quite prescriptive about procedure and leaving it to the freedom of the dispute board. I don't think I've got time to talk about notices of dissatisfaction, but maybe Aisha, if we get onto that in questions, I can do so.
Perfect. Thank you very much. And thank you, Charles, for sticking to time and for, doing quite a very comprehensive comparison in that time. But now I'd like to turn it over to Dr. Elke Paschl to kind of give us the view from an institutional user's perspective, and that being the African Development Bank. Elke, the floor is yours.
Thank you, Aisha. And thank you very much, Dr. Ismail, for inviting the African Development Bank to give a view from its perspective on the use of dispute boards. I am going to focus on 3 subjects. The first will cover the question, what kind of dispute resolution mechanisms are foreseen under the AFDB finance projects? The second will outline specific dispute board provisions in AFDB's procurement policy. And at the end, I will share practical examples of our experience with dispute boards. To start with, the bank's dispute resolution mechanisms are currently mainly included in large civil works contracts, including supply and install contracts. However, they can be extended to any bidding documents when a high risk has been identified in this regard, for example, complex service contracts. There are 4 stages in dispute resolution provided for by AFDB's procurement framework. The first constitutes conciliation, which is a sort of mediation through the supervising engineer. If conciliation fails, the parties may turn to what we call dispute avoidance or adjudication boards, DAAB, whose decision shall be binding on both parties unless it is revised in an amicable settlement or an arbitral award. If an amicable settlement cannot be reached, last resort can be sought in arbitration as the 4th step. To begin with, I would like to clarify the contractual roles under AFDB finance projects. While the bank may finance a works contract under its projects, the bank is not a party to this works contract, as it is signed between the contractor and the executing agency only, while the bank is signatory to the loan agreement with the borrower. So therefore, the responsibility for contract management, including dispute resolution, rests with the borrowing country or its executing agency. The parties therefore must first seek to resolve any dispute amicably by conciliation efforts to allow swift project implementation through mediation of the supervising engineer or a third-party expert called in to informally resolve issues and avoid the appointment of a dispute board or ultimately going to arbitration or litigation. In such situations, the expense of such third party may be borne by a single party or, if agreed, can be split evenly between the two. If conciliation fails, the bank allows for the appointment of dispute boards, the concept of which can be used in both civil law and common law contexts. The dispute board must be set up as a standing or full-term board at the beginning of the contract execution and be in place for the whole duration of the contract. The bank advises against ad hoc DBs as their selection and mobilization may take considerable time, which may cause delays in contract execution. The list of potential DB members proposed by the employer and by the bidder is subject to the bank's no objection. However, under no circumstances can the bank be named as a dispute board member or be requested to recommend a dispute board member. As to the composition of the dispute boards, the bank recommends that for a works contract estimated to cost above $50 million, the dispute board shall comprise of 3 members. Between 20 and 50 million, the board may comprise of 3 members or a sole member only. And for contracts of less than $20 million, a sole member is recommended. Where a notice of dissatisfaction with the DB's decision has been given, both parties shall attempt to settle the argument amicably before the commencement of arbitration. Under the bank's rules, arbitration is conducted differently depending on whether only domestic or also foreign contractors are involved. For works contracts with foreign contractors, to ensure some degree of impartiality, international arbitration shall follow either proceedings administered by the arbitration institution designated in the particular conditions of the bidding document, or international arbitration in accordance with UNCITRAL, or if neither an arbitration institution nor UNCITRAL arbitration rules is specified, proceedings shall be administered by the ICC. For contracts with domestic contractors only, arbitration shall follow proceedings conducted in accordance with the laws of the employer's country. Similarly, as the bank cannot recommend any member of a dispute board, the bank can also not be named as an arbitrator, be requested to recommend an arbitrator, or be cited as a party in an arbitration. Lastly, I am sharing with you a few of the observations made when going through some of the DB cases found under bank financed contracts. When it comes to the types of contracts encountered, maybe not surprisingly, they all referred to large civil works contracts, while, as I mentioned before, dispute boards could also be foreseen for other categories of procurement. As to the composition of the dispute boards, in practice, all cases consisted of standing dispute boards of 3 persons and no case of only 1 member. There was also no ad hoc board found. Half of the opinions were derived on a documents-only basis, based on the position papers and documentation provided by the parties, while half of them had also held hearings. Again, about half of these decisions did not contain any reasons. However, whenever reasons were provided, we found them very useful, as the dispute boards used this opportunity not only to outline the limited scope of the question at hand, but also to give guidance to both parties on additional issues to be anticipated and carefully considered. This initiative of the DB constitutes valuable assistance in dispute avoidance. Concluding, the AFDB fully supports the use of dispute boards, as they are found to be beneficial not only in dispute resolution, but also, and even more importantly, in dispute avoidance, which is crucial for fast project implementation. Thank you very much. Back to Aisha.
Thank you very much, Elke. Quite helpful. And the audience is definitely giving us some questions. And I'd like to kind of set the stage or kind of proceed, taking into consideration with everything that the panelists said and what is coming through. And the question is as follows. We heard a lot about dispute avoidance and dispute resolution and the definition of a dispute versus Nael saying something about a disagreement. And we have some questions about the difference between conciliation and mediation and arbitration. And so before we get into some specifics, Nael, can I turn it to you? And if you can, Ahmed told us to focus on definitions when we're reading the rules. And one of those definitions is the defined term of dispute in the CRCICA rules. So what effect does that definition have on the avoidance of dispute? Because I think we all agree that we want to avoid disputes and we want to have standing boards to avoid disputes. But help us understand the definition and how it works with avoidance.
Well, I fully agree with Dr. Waly that one of the most important sections is section 1, although it looks simple. But really the definition of what you're talking about is most important. Whereas you can define a term in any way you like, it is foolish to go on and define it in a way that is different from what is generally accepted, internationally accepted, or even legally accepted. So I'm really very pleased to see that dispute in item 8 of section 1 is defined as means an assertion of a right or a claim by a party that has been rejected by another party. Such rejection is rejected by the former. This is, generally speaking, the accepted definition of dispute, not only internationally, but also legally. And if I may draw your attention to two things. First of all, dispute really is defined by the term claim. So it first starts with a claim. The claim is rejected and the rejection is rejected. That's the first thing that I'd like you to keep in mind. The second thing is, that I refer you to the legal meaning of it. It's taken from the AMEC Civil Engineering Limited versus Secretary of State of Transport decision in an English case. The decision was issued in October 2014, but it was approved in March 2015 by the Court of Appeal, and it had 7 items to it. The first one was that the word dispute, which occurs in many arbitration clauses, should be given its normal meaning. What is therefore the normal meaning of a dispute? And why did I bring the term disagreement to it? That is because in order to avoid a dispute, you must look at the beginning of how a dispute arises and what I call the manifestation of a dispute. So if you look at the word claim in that dispute definition, you see that it's way down the list. The dispute starts by a recognition of a problem. That recognition, if it's not resolved, it goes into an accusation. And that accusation then reaches disagreement. And that's why FIDIC chose disagreement as a middle stage in its rule in the Gold Book. It ended up by first a disagreement, then you go into a claim once the disagreement festers, and then the claim becomes a dispute. And as I say, I repeat, that is very, very important. It's correctly followed by these rules, and I'm very pleased to see that it is done in that way, rather than some other situation where it brings its own difficulties. Because if you go beyond the acceptable way, then you bring in another confusion into the purpose. And it's already a problem to define a dispute, to manage to see where the dispute is, besides getting into another area of a new definition, which is meaningless when you compare it with the legal definition.
Thank you, Nael. I'd invite our other panelists to see if from a practitioner's point of view, Charles, do you have any comments or?
Yeah, I mean, I would just say a lot can be this can be over-engineered sometimes, and a dispute really is very fact-specific. And I completely agree with Professor Bunni's summary, and I know that AMEC case very well, and I think it's a very sort of common sense view as to what is a dispute. But in practice, I haven't really ever come across, I'm just thinking about all the dispute boards and all the adjudications I have done. You tend to know when you're in a dispute situation, and in terms of getting a decision needed, by that stage, you're pretty clearly in a dispute situation. So it doesn't come up as often as I think can sometimes be suggested in theory. But that's just my experience.
Thank you, Charles. I mean, I think it is. I like the word common sense. You really have to know what you're trying to do, and if you're actually in a dispute, then if you and are trying to resolve it, or are you in a prior phase in a disagreement or having an issue, and then you can actually avoid that escalating into a dispute. And so parties are advised to keep that in mind. And I think if we agree that if we can resolve or avoid disputes in the first place, we are better equipped to go on with and reach project success. But there's an investment to these dispute boards. Elke was saying the recommendation for over $50 million is 3 members, or only when you get to $20 million project is it a 1-member dispute board. Ahmed, are you finding that in the region with the current culture, both of the national culture and the industry culture in the region, are dispute boards cost effective?
Okay, thank you, Aisha. Actually, I was supervising research at one of the universities studying the application of dispute boards in Egypt. And we will publish 2 papers at the Journal of Legal Affairs of the American Society of Civil Engineers. And we had 2 case studies on how cost-effective are the dispute boards in 2 mega infrastructure projects in Egypt. And we found that the number or the amount of disputes that were solved through the dispute board were humongous. And if these disputes were not resolved, they have been escalated to arbitration. And as you know, arbitration is usually, or the cost of arbitration is relative to the amount in dispute. So the amount in dispute resolved through the dispute board were humongous, and definitely the cost of arbitration would have been much more than the cost of dispute boards. And we have this as a research in numbers. The idea of the dispute board avoidance and the atmosphere of communication between the parties that the dispute board members are creating, I think, is key in solving the dispute without this escalation.
Thank you, Ahmed. I was just trying to, we were going to be joined by another colleague from the African Development Bank, and I'm having a little technical issues with him joining at the moment. But we have some audience questions that I'd like to kind of interleave, and we have one question. A lot of this revolves around the dispute avoidance, and is it like mediation, or is it nearly a mediation role? And how, you know, if we're trying to resolve or avoid all these disputes, why do we then need a DAAB or a full-on dispute board? And Charles, can I invite you to answer that?
Yes, of course. Just to be clear, I think that the dispute board providing an informal assistance function is not necessarily the same as acting as a mediator. The dispute board can provide and function in providing an informal opinion, or an opinion on something which isn't binding, or give some initial views on the interpretation of a contract clause, for example. Which can then be usefully used by the parties to go away and come to a sensible conclusion. And the dispute board can have a useful function in that respect. My bit of my presentation where I was raising issue is where a dispute board goes off and meets with one party without the other party being present. And I think when it starts to do that, there is a danger that its impartiality is undermined, but that is a slightly different issue to sort of but to being able to provide an avoidance function, which I think is a very important function of a dispute board.
Thank you, and I think the idea of impartiality, and Dr. Ahmed Waly talked about the requirement for the member to be impartial, but I would, and he said it quite eloquently, and I believe that trust in the member and trust in the process is foundational to this, for this process to be effective. So although we're touching upon impartiality and the requirement for it, in passing, it is something that really needs to be underlined. Before we go further, I'd like to welcome Mr. Malik Fall, the Chief Regional Procurement Coordinator of the African Development Bank for North Africa, and he's based in Tunisia. I'd like to welcome him to share his experience on dispute boards operationally. He is a civil engineer and has over 30 years with many development banks and 17 years with implementing projects on the ground with the African Development Bank. Before I turn to him, I'd like to ask Elke, there is, I think the African Development Bank had undertaken a study of various institutions around Africa, which also featured CRCICA. Can you let us know what the results of that study were?
Yes, thank you, Aisha. It's in 2014 that the African Development Bank undertook an assessment of several international arbitration centers in Africa, and CRCICA, in fact, was found to be one of the best arbitration centers across the continent. The report concluded that CRCICA could readily be recommended for use by parties from both the African continent and elsewhere. To your information, the other arbitration centers found acceptable were in Cote d'Ivoire and in Mauritius. The professionalism of CRCICA and the suitability of its rules for the conduct of international arbitration proceedings had been stressed by various interlocutors. The only issue that we found related to practical rather than legal concerns had to do with the fact that at that time there was no French version of CRCICA's arbitration rules, which I understand, however, that meanwhile these rules have been translated a few years ago and that French-speaking arbitrators are available to conduct proceedings also in the French language. I also understand that proceedings had been undertaken already in French.
Well, this is good to know that as from the African Development Bank perspective, that for administration purposes or administrating arbitrations, CRCICA was found to be one of the recommended institutions in Africa. That brings me to administering proceedings for dispute board rules. And I think that's one of the unique features of the CRCICA dispute board rules of administration and providing that service. And so if they administer well arbitrations, they'll administer well dispute boards. But there's a fee for that. So Charles, do you think your clients and prospective practitioners would pay that fee, and who would be willing to assess that fee?
A really good question. And I think I would do the classic lawyer's answer and just say it depends. It depends on the project, it depends on the client. And just to say, to be clear, the CRCICA offers the usual type of services in terms of nominating a dispute board member, deciding on challenges against that member, determining dispute board fees that we're familiar with the ICC rules of. What we're talking about here is sort of the additional optional administrative services, such as providing meeting facilities, secretarial services, translation, and all that really good, useful support services. Now, and I have to say, I think it does come at a very good value, and I'm not being paid by CRCICA to say that. But the thing I would point out, so the types of dispute boards I tend to get involved with on the multi-billion-dollar projects with big disputes, with experienced dispute boards, with parties able to pay. It tends to be the administrative side of things tends to be done between the parties, their advisors, and the dispute board members. And meetings are just arranged at a neutral venue in whichever country to suit. But for sort of the smaller value, those less familiar with dispute boards, I think the administrative services are a fantastic tool, and that would hopefully encourage their use in the region.
I think in a nascent market where dispute boards are being introduced in the Middle East, still growing, then this administrative service has a place. I'm also familiar with the idea of administrative service from a public sector requirement. And I'd like to invite Mr. Malik Fall, who just joined us, to give us an operational view of the African Development Bank using dispute boards on the ground. Mr. Malik?
Yeah.
Welcome.
Good afternoon. Thank you for inviting me. I hope you can hear me very well.
We can hear you. I can just see your glasses, though.
Sorry. So, okay.
So if you could just briefly...
sorry, so quickly.
Yeah.
I think the panelists have already touch upon some cases and some experiences in terms of using the dispute board with Charles and Elke. So I think just briefly, definitely from African Development Bank perspective, yeah, the dispute board are essential. We have noted, for example, when you have a standing dispute board that can visit the works, can go to the site regularly, this is something that we have to promote, definitely, because they can definitely help to ease some early dispute and even also address and anticipate some kind of claims that when they are visiting the construction works, when they are going to the site as a standing DB. This is something that is very important in terms of remedies that I have noted from my experience during the last 12 years. So another point is just that to notice that the DBs, the dispute board, also can fast track the implementation of large contracts, and is, for example, the dispute board intervene across several issues, from, for example, issues related to change in the law, in terms of increase of petrol in the law. For example, if you have the pay scale, the payroll has been increased, or also issues related to the employees of a given contract. So as well as any aspect related to the time, to the additional cost, is something that is very, very key for a successful implementation of a contract. Thank you very much.
Thank you, Mr. Malik. I think that underlines the entire idea that the dispute board, and I think we all agree that it needs to be a standing dispute board to visit the site, understand, keep abreast of the information, and then therefore they can add real-time value and getting the parties' heads around the issues and addressing issues real time and resolving disputes, also making decisions real time. And I think we can all agree on that. I am cognizant that we are just at time, but I also am going to take the liberty, being of Egyptian background and not taking on my Swedish hat, and saying, we can take a little bit more time with the panelists' permission, if they don't mind, to answer questions, because I understand that we have a question. Dr. Ismail said that there's an audience member that has a question. So I'd like to give maybe 5-10 minutes to audience questions. And then I'd like to give an opportunity for every panelist to have some final thoughts. So maybe some 10-15 minutes extra. So I'm not being Swedish on this occasion. So Dr. Ismail, I understand that there is a question that, would you like to give the floor to a particular panelist to ask a question? Did I misread the Gaston Kenfek?
Yes, there are two issues. Mr. Gaston Kenfak, who is a member of CRCICA's Board of Trustees, we are honored to have him with us today. So we will exceptionally give him the floor to ask a question. And there is the question on the new amendment of the Supreme Constitutional Court law. And there was a question about whether it affects the decisions of CRCICA. The answer is no, and I'm happy to explain briefly why. And so if there is time, we can handle these two issues. So if you permit me, we give the floor to Monsieur Gaston Kinfack, Dr. Gaston Kinfack.
With pleasure. Dr. I think you're on mute, Doctor.
Can you hear me now?
Yes.
Yes, sir.
Thank you. This was quite a very interesting topic, and I'm very happy, not only because I'm a member of the board at the CRCICA, but because it's, to my best knowledge, the first institution in Africa to adopt such rules. To my best knowledge, the first meeting organized by the Dispute Resolution Board Foundation in Africa took place in the 2nd, 3rd, and 4th of May 2008 in Cape Town. And I was invited by the World Bank to attend this international meeting. And I remember I was alone from the French-speaking part of Africa. And the purpose was to promote this instrument that is a very accurate instrument for the avoidance of dispute, as you have said it. But my problem, even though the African Development Bank is there today, and also happy for that, my impression is that dispute board is not effectively popularized in Africa. And I would like to take this opportunity to ask why this impression from the World Development, the African Development Bank. I am currently in Cameroon, and we have dispute in arbitration concerning construction of infrastructures. And my impression is that if the dispute board has been accurately used in these cases, we would have avoided this dispute. So this is a prayer. I congratulate CRCICA for the adoption of these new rules. And my prayer is that they should promote and disseminate this instrument in Africa. That was for the comment. And now, my question, I have a question to Charles Blamire. I think maybe I was wrong I didn't get him very well, but my impression is that he would like the dispute to have more than 3 members. And if it's the case, my question is, doesn't he think that more than 3 members could hinder the effective implementation of the dispute board? Thank you for your availability. And congratulations again for this wonderful initiative. Thank you.
Thank you, Dr. Gaston. And Charles, I can imagine I can answer for you, but I will let you answer for yourself.
No, that's absolutely fine. And thank you very much for the question, Dr. Gaston. Again, it's a lawyer's answer, but it depends on the nature of the project as to the number of dispute board members you might want to have. The standard is to have 1 or 3. Only on the very biggest projects, and I'm talking Hong Kong Airport, where there's been 7, would I expect to see a bigger number than the standard 1 to 3. And even then, those dispute boards might not necessarily mean that every single member attend site every time. They operate more as panels where you might call off a particular expert to advise a given opinion on a particular issue. Very rarely have I seen more than one or three. Only on the biggest projects have I seen that being used.
Thank you, Charles. And the only thing that I would add to the possibility of having more than three, it gives a flexibility. If you have a complex type of project with a variety of different expertise, you would have a standing group of people that are not involved in every dispute, but then you would have a selected chair that can select from that. So if it's a civil problem, you can select from, if you have a standing panel of 7, then the actual resolvers of or decision makers on a particular dispute would be the chair plus the 2 experts in civil works, and you would have something in electrical works or the like. So it gives it's a different construct than what we're normally used to, but the resolvers of a particular dispute would only be 3, like you're saying, with the chair being specified. So it just gives a flexibility to tailor. And this is the beautiful thing, I think, about dispute boards in general, that they can be customized. And this is the tension that Charles pointed out, between being too prescriptive on procedure and allowing the flexibility to kind of customize it and tailor it for this to suit the particular project on the ground. And sorry to have, as a moderator, to have added to that, Charles, but I note that we have in another question, and Nael, can I ask you, the question really revolves around this DAABs and dispute boards being involved in this avoidance and then being involved in potential decision making. I'd like to have a comment from you on how to kind of not create confusion when you're resolving a dispute and that you may potentially have to decide. And the audience, there's several questions on saying, how can you achieve avoidance and then you might have to be resolving or making a decision on this dispute, and can that actually be practically achieved? Nael?
Well, if I may comment first on this aspect, and that is that you don't have to mediate or negotiate in order to avoid disputes. Disputes can be avoided by simply resolving a misunderstanding. And from my experience, I think that is where the problem lies. The 2 parties misunderstand each other. And the role of the dispute avoidance mechanism of the dispute board is to try and explain the position of the parties to each other and ask them to put themselves in the shoes of the other party. And you find a lot of the questions then can be resolved by the parties themselves. So I agree, if you start mediating, then you are creating a problem. Because exactly as was explained, you end up in having, in the first instance, making a point, and then you may end up having to shoot yourself in the foot by saying, I was wrong. And so if I concentrate on the role of the DAB to try and explain the problem first to the parties and ask them to see if there is a solution by putting themselves in the other party's shoes, I think that would resolve quite a lot of problems. But if I may comment on another aspect that has arisen, and that is, why do dispute boards not be used? Why are they not used more often? And I think it is the owners of the projects that are to be blamed, because they think there's an additional expense, additional payment to be made to the dispute board members, which needn't be made. And so they think that this adds up to the cost of the project. And that is, of course, very wrong, because in fact, the cost, as Dr. Waly said, and I agree with him, cost of arbitration is many, many times the cost of dispute boards. So if you look at it from that point of view, I really would encourage owners to try and use boards, dispute boards, more often, more freely than they do them now. It is a very important aspect. And if you think of it, if you think of the cost of dispute boards being an insurance against arbitration, you may find that that simplifies matters in the minds of an employer. Why should he pay this additional amount of money to a dispute board? Whereas if you think of it as an insurance aspect against the possibility of having to arbitrate, you may find it very simple to answer that question.
Thank you, Nael. Elke, you had a point?
Yeah. Thank you, Aisha. To respond to Dr. Gaston's suggestion for the African Development Bank to more promote dispute boards, I can confirm and also comfort Dr. Gaston that under the bank's standard bidding documents for works, as a rule, the constitution of a dispute board is not only mandatory, but it even constitutes a condition precedent to the engineer's notice to the contractor stating the commencement date for the execution of the works. So if it's a bank-financed project, the dispute board is even mandatory. If I may, Aisha, may I also answer a question that was asked by Mr. Ahmed Waly. You are stating, is that in your institution, you do not make any difference between mediation, arbitration, and conciliation. I have to admit that in my presentation, I did use the term mediation, while that's a term, you know, I used it in the interest of time when talking about the interference of the supervising engineer. However, I can confirm the only terms defined in the banks, in the African Development Bank standard bidding documents are conciliation, which includes amicable and informal dispute settlement, and arbitration, which of course is a different type of animal, which requires the recruitment of an arbitration center. Thank you.
Thank you for that clarification, Elke. And I would, as a listener to both Dr. Gascon and to Dr. Elke on their I would say, and to what Nael said about employers' hesitancy, I would say that we all need to engage in education and collaboration of the employers and understand their fears, address their fears, and mandating is, well, I hear that's really good to have, the African Development Bank is now mandating it, but maybe working with your borrowers and helping them understand and alleviate their fears. Maybe we all engage with CRCICA and just focus on collaboration. There are other questions that deal with the Egyptian law and this new Egyptian law, and Dr. Ismail indicated that he will be writing an article on how dispute boards fit within the new Egyptian law and arbitration. So I will wait for that. And I think we'll all wait with interest for that. But now we've really gone over time, and I even with my Egyptian background, I can't ask for any more from our esteemed panelists. But I would like to go around the table and ask each of our panelists for just a minute or two of final thoughts. your takeaways from today. And Charles, I'll start with you.
Always pick on the lawyer. Look, I think the CRCICA rules is a very positive step towards the use of dispute boards in the region on the African continent, and I can only welcome it. I think is a very, very positive step. The one thing I would say in terms of the success of dispute boards, in my experience, and their take-up is in the quality of the dispute board members appointed, and if they have the respect of both parties, then they tend to be very effective. And I think in that, I would say this because I'm speaking on a panel with a number of CRCICA adjudicators on the list, but I think CRCICA are developing a very, very impressive list, and that's very encouraging.
Dr. Elke, may I turn it to you for your thoughts?
Thank you, Aisha. Again, from our perspective, maybe similar to our assessment of the arbitration rules, it will be important for us and also maybe for CRCICA not to limit its attractiveness, to make sure not to only have dispute board members that are fluent in Arabic and English, but also in French, please. Thank you.
Well noted, and we're working on that as we speak, and we also have some already that are Francophone. So, Mr. Malik, any final thoughts?
No, just to thank you, Aisha. Thank you, you and the CRCICA, and all the team for inviting us. So just to we fully back this initiative as a first financial institution, and this is something that is very important. This is responding also to Mr. Gaston's question in terms of sharing good practices and to populate this kind of information to all our members, our members in Africa and around and in other regions as well. Thank you. I don't have much to say, and just to thank you again. Thank you.
Thank you. Dr. Waly, your final thoughts.
Okay, thank you. I just want to say that I truly believe in the effectiveness of dispute boards, and I can't agree more on Professor Bunni's comment regarding the misunderstanding which lead to disputes. And I always believe that the misunderstanding is usually due to miscommunication. And one of the main roles of the dispute boards is to create an atmosphere of communication between the parties. Finally, I also believe that the dispute board rules of CRCICA will definitely promote the use of dispute boards in Egypt and the region. Thank you.
Thank you. Professor Bunni?
Well, the most important thought I think that I have at the moment is that it was a great effort and a great achievement for the production of these rules. But I think the next step is even more important. That is to convince employers to use dispute boards. And that can only be achieved by letting them know the benefits of such dispute boards, why the cost of dispute boards is very little compared with one case that could be prevented from going to arbitration. I can give you some horrendous statistics of the cost of arbitration, whereas having worked as a dispute board member, the cost will disappear into very little compared with that cost of arbitration.
I couldn't agree more, Nael. You often say that dispute boards are an insurance cost
Yes.
sometimes against
Yes, indeed.
installation. And I couldn't agree and share your experience. And with this esteemed panel, and with all the comments and all the insights that you've shared so generously about disputes and experiences and the CRCICA rules, I think we have, you have managed to launch these rules, help launch the CRCICA rules on the right foot. And for that, I thank you. I thank you for your generous time and your generous efforts in making these rules come into a reality, and for so eloquently and generously sharing of your experiences and your insights with the panelists. It's been both a privilege and a pleasure for me to moderate this session. Thank you again to all the panelists, and I welcome all the audience participants. Again, we're having another session tomorrow morning to reach out to our Asian time zone partners. We'll be joined by another set of speakers. You will have seen the advertisement or the LinkedIn communication, and we invite you to come to that and maybe seeing a different perspective, but we also invite you to let your colleagues and friends know about the CRCICA rules. And as I understand, this will be a taped session and be available on the CRCICA YouTube platform. So therefore you can watch it again, or for those of you who might have missed parts of it, can undertake to find it there. And with that, I turn it back to Dr. Ismail and Dr. Gaston as the board member and the director of CRCICA. Thank you, and I bid you good night. Dr. Ismail.
Thank you very much, Aisha, for your excellent moderation of this event. Thank you very much, dear distinguished panelists, for your very informative contribution, which have led to the success of this event. I also want to thank my colleagues at CRCICA, Ms. Heba Rushdi and the IT team led by Engineer Yahya and Engineer Sharif for their tremendous work in preparing and supervising technically this successful event. In addition to, of course, inviting employers, contractors, and financial institutions to consider the CRCICA dispute board rules, and also to reassure those who are concerned about the Supreme Constitutional Court law, just to say a word, but I will write in detail about this. The CRCICA's decision to appoint a dispute board member or to recuse a dispute board member or to provide administrative services are not triggered by this law. It is not a titre exécutoire, the execution of which would be sought against the state. So this law concerns foreign judgments and decisions of international organizations. And the word foreign arbitral tribunal has been removed from this law. And I would like to mention also that the CRCICA enjoys an immunity against jurisdiction by virtue of its headquarters agreement. And the Egyptian state has respected for 40 years and more the independence and the immunities of the CRCICA throughout its existence. So rest assured about that. One last word is that we should work hardly on training to create more experts in the field of dispute boards, especially on the African continent. And we are taking into consideration Dr. Elke's recommendation to have more dispute board members who are fluent in French. And together with the finalization of our French version of the dispute board rules, you will hear about a list of French-speaking dispute board members who are qualified to handle this type, to adjudicate this type of disputes under our rules. Thank you all the participants. We are very thankful to you, and we hope that you will attend tomorrow's second inaugural event, and I'm sure you will listen to other distinguished panelists, and hopefully you will learn more about this very interesting method of dispute settlement. Thank you all, and now we need to close and to put an end to this launch, successful launch event. Thank you all.
Thank you and good night, everyone. Thank you.
Thank you. All the best.
Thank
Bye-bye.
Thank you.